So we'll handle Shelby Ranch versus Jaren Humphrey and Jodine Humphrey and Michael Humphrey. I think we missed Miss Humphrey somewhere. We dropped her off. We need to bring her back in. Very, very good. All right. Good morning, everyone.
Morning, Your Honor.
How are y'all doing? Everybody doing okay?
Yes,
For the
sir.
most part. Okay, great. All right. I think I'd formally call the case C1CV26-0528 Shelby Ranch Investment versus Jaren Humphrey and Michael Humphrey. If you would go ahead and make your appearance for the record, beginning with counsel for the plaintiff.
Erin DuBois on behalf of the plaintiff, Shelby Ranch Investments LP, doing business at Shelby Ranch. And I have my client's representative, Mr. Quavius Griswold, as well.
Thank you. And then, Mr. Humphrey, you're here. Go ahead and take yourself off mute. I just want to get you on the record that you're here.
Here.
Thank you, Mr. Humphrey. And Ms. Humphrey,
right.
if you wouldn't mind taking yourself off mute.
I'm here.
Okay, thank you all very much. All right. This is a trial de novo from the JP court. Court notes that there's 2628 in the registry of the court. Generally, how this goes is sometimes there's a motion. So I don't think I see a separate motion, but the order of things is plaintiff will give a brief opening statement or they waive it. That's just kind of a snapshot of what the case is about. Defendants can also have an opening statement as well. Once again, snapshot of what they think the case is about. And then we just move into evidence, testimony called from the plaintiff and any exhibits they wish to offer. Defendants have an opportunity to cross-examine any witnesses and make any legal objections to any documents that are offered. After the plaintiff is rested, defendants then have an opportunity to also call witnesses and make offers of proof through evidence documents. Defendant will present those. Plaintiff will have an opportunity to make any objections to any documents and, of course, cross-examine the witnesses. After the parties have completed their presentations, plaintiff may do a closing statement. Then the defendants have an opportunity for a closing statement. And then plaintiff in their role as plaintiff gets the final say. Generally, these don't take too long. Generally, the parties do agree on certain documents. If this is a contract, they'll talk about the contract, notices, etc. So that being said, Ms. DuBois, do you have an opening statement?
Yes, Your Honor. I do want to note for the court that we did file a notice of rent default under Rule 510.9.
Okay, I don't have that. Let me see what that might be. Just give me a second. I need to pull up Smart Bench. Kind of a paradoxical name. Hold on just a second. I saw me struggling using the app for documents. Hold on just a second. All right. So on February 27th, 2026, Shelby Ranch filed a notice of default under 510.9C and request for writ, and we'll address that first. You may proceed, counsel.
Thank you, Your Honor. Your Honor, the defendants in this case, Ms. Humphrey and Mr. Humphrey filed the appeal from the Justice Court by filing a statement of inability to pay. Justice Court judgment was rendered on January 8 of 2026. That was appealed on January 14, and a registry payment was made to the Justice Court registry on or before January 20 of 2026, pursuant to Rule 510.9C, 5B, well, I guess it's no Roman numeral 2. The defendants were required to continue to pay their registry payments into the county court registry I believe that a payment was made for February in the amount of $1,314. So in total, the amount is that $2,628 in the court's registry. However, we're now into the month of March, March's rent has become due. And as of yesterday afternoon, the defendants had not tendered the March rent into the court's registry. So we are seeking an immediate writ of possession here today for the property under the former, Texas Rule of Civil Procedure 510.9C that applies in this case as it was filed prior to January 1st of 2026.
Thank you. Mr. Humphrey, Ms. Humphrey, did y'all make that payment for March?
I haven't yet. I was told by the court that I had until the end of the 5th. So I honestly didn't know. So I have the court email. So I don't know what information Aaron has, but that's just the information that I was given by the court.
Okay, thank you. It is by the end of the day on the 5th day of the month. And today is the 5th. So I'm going to deny the motion for the immediate writ, and we'll go into the main part of the case then. Ms. Boyd, do you have an opening statement?
Yes, Your Honor. This case is a non-payment of rent case. My client is seeking possession of the property from Mr. Humphrey and Ms. Humphrey. They're also seeking award of the back due rent that is due and owing. And I believe the evidence in this case is going to show that my client has a superior right to possession of the property, as well as a right to recover the monetary sums for the unpaid rent and the attorney's fees that my client has expended in this case, as well as interest on any judgment that would be rendered.
All right, thank you. Mr. or Ms. Humphrey, do you want to give an opening statement as well? In fact, before you do, since y'all are going to be essentially testifying, I'm going to go ahead and swear any witnesses in. If you're going to be testifying today, go ahead and raise your right hand. Let me go ahead and swear you in ahead of time. Do you solemnly swear affirm the testimony you're about to give in this matter shall be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Yes.
Thank you. Everybody said, I do. All right, perfect. All right,
Yes.
Mr. or Ms. Humphrey, anybody want to give an opening statement?
Yeah, well, I really don't have much to say. I didn't submit any evidence because everything that I've done has been in good faith. The whole reason that I even wanted to go with the court hearing instead of talking with Quavius about the rent originally in November is because I was looking for mediation, because I was under the impression that there was retaliation involved. And, like I said, I came here in good faith, hoping that I would be able to see justice, that I would be able to receive some sort of mediation for just the whirlwind of confusion and just honestly weird behavior that I've gotten from Quavius and Jasmine. And I just didn't expect eviction court to be like this. I didn't expect judges to not look at the evidence, automatically side with the landlord. So it was new for me, but I'm a Christian. I submit to the Lord Jesus Christ, and he's the one who has been giving me he's the one who told me they retaliated. And so I came here in faith that I would see the evidence of my faith. And Quavius's email to me on, I think it was shortly after the hearing, before I filed the appeal. I had thought to myself, well, maybe they didn't retaliate. That's what they said. They said they didn't retaliate. And then I saw his email, and he was essentially mocking me in the email. And so I said, okay, well, Lord, what do I do? And so
Hold on. You're starting to testify, and all I needed was an overview of the case. So,
okay, well, I'm letting you know that I submitted the appeal, and it was 2 days past the deadline, but it was still accepted. And so I'm just here. That's
Okay.
just
Right.
that's my statement. That's
Okay.
I'm not fighting anybody. I'm just here.
Okay. All right. Thank you.
You're
All
welcome.
right, Mr. Boy, you may present your case in chief. Call your first witness.
Thank you, Your Honor. The plaintiff calls Quavius Griswold.
Thank you. Unless you're testifying, go ahead and put yourself on mute. Mute. Thank you. All right. Mr. Boyd, you may proceed.
Thank you. Mr. Griswold, where do you work?
At Shelby Ranch,
All right, what's your position there at Shelby Ranch?
the community manager.
And you are appearing as authorized representative of Shelby Ranch Investments LP, the plaintiff in this case?
Yes, I am.
Okay, and you're familiar with the tenancy of Miss Jaren Humphrey and Mr. Michael Humphrey?
I am very familiar.
Okay. Do they reside at 2210 Lynbrook Drive, apartment 1432 here in Austin, Texas, 78748?
Yes, they do.
Okay. And their occupancy at the property, is that governed by a written lease agreement?
It is, yes.
Your Honor, would you like me to go ahead and share my screen?
Yes, please.
Okay. All right. Mr. Griswold, do you see my screen here?
I do.
Okay. Is this a true and correct copy of the lease agreement between Shelby Ranch and the Humphreys?
This is correct.
Okay. I'm going to scroll down here to the bottom. Lease agreement is electronically signed by both the defendants, correct?
Correct.
Okay. And this hasn't been amended, but for my marking of Plaintiff's Exhibit 1?
No, no amendments have been made.
Okay. Your Honor, we offer Plaintiff's 1.
All right. Any objection to Exhibit 1? Hearing none, Plaintiff's Exhibit 1 is admitted.
Mr. Griswold, on page 1 of the lease under box C, what is the defendant's monthly rent?
$1,314.00.
And has the Humphreys failed to pay rent beginning in November of 2025?
That is correct.
Have they also now failed to pay rent for December 2025, January, February, and March of 2026?
That is correct.
So under paragraph 3 and 3.5 of the lease, is failure to pay rent and all other amounts due a violation?
Definitely.
All right. And if you, I'll go ahead and scroll down here to paragraph 23.1, is failing to pay rent, including all the charges under the lease, a default of lease which entitles Shelby Ranch to possession of the property.
Yes.
Are you seeking an award here today of back due rent of $1,314 for each of the months of November 2025, December 2025, January, February, and March of 2026?
We are.
All right, and that would total $6,570, correct?
That is correct.
Now, under paragraph 23.5, are you seeking Shelby Ranch's reasonable and necessary attorney's fees here today?
We are.
Are you seeking post-judgment interest on any monetary judgment that would be rendered in the amount of 6.75%?
We are.
And are you seeking your costs of court from the eviction?
We are.
Mr. Griswold, I'm pulling up what's marked as Plaintiff's 2. Do you recognize this document?
I do.
Is this a true and correct copy of the notice to vacate that was delivered to apartment 1432 on November 10 of 2025?
That is.
And but for my marking of Plaintiff's 2, has this document been amended?
No amendments.
Okay. Your Honor, we offer Plaintiff's 2.
Any objection to Plaintiff's Exhibit 2? Hearing none, Plaintiff's Exhibit 2 is admitted.
Mr. Griswold, I'm going to go ahead and go down here. Did you deliver the notice to vacate?
Yes, I did.
All right. And did you hand deliver that to Ms. Humphrey?
Yes, we did.
Okay. Mr. Griswold, I've pulled up what's marked as Plaintiff's Exhibit 3. Do you recognize this document?
Yes, I do.
Is this a true and correct copy of the resident ledger or accounting for apartment 1432?
That is correct.
Okay. And this indicates that the last payment received that was not returned for insufficient funds was on October 15 of 2025, correct?
That is correct.
Okay. Your Honor, we offer plaintiffs 3.
All right, any objection to Plaintiff's Exhibit 3?
I have one. Jasmine was the one who handed me the notice to vacate.
Okay,
Chloe-
hold on. I just
Mhm.
need a legal objection to Plaintiff's
Okay.
Exhibit 3. Do you have one
Okay.
for Exhibit 3?
Well, it's just incorrect information that.
Well, and you can challenge that, or you can
Okay,
talk
well,
about it.
all right. Then I don't have any
Okay.
objections to.
Okay, all right. You'll have a chance to talk about all
Okay.
this here in just a minute. Plaintiff's Exhibit 3 is admitted.
Mr. Griswold, has the defendants, they're still in possession of the property, correct? You don't have keys.
We do not have keys from them. They are in possession.
Okay. And as of today's date, you have not received payment for the full amount that is due and owing.
That is correct.
Okay. Your Honor, I pass the witness.
All right, thank you. Mr. or Ms. Humphrey, do you have any questions for this witness? Do you have any questions for him?
I don't really have any questions other than just
Okay.
like asking Quavius, is it typical protocol for both of the managers to hand a notice to vacate to a tenant?
We do that. That way we have a witness.
We can't hear you.
I can't hear you.
Hold on, we can't hear you. You sound like you're underwater. Your microphone's been pretty blurby up till now. We've been able to hear it, but not very well on that.
How about this? Is this a little bit better?
A little bit better. You just need to be closer to the mic because it's picking up. It's kind
I'm
of one of
sorry.
those big mics.
To answer that question, yes, we do use that as our standard protocol. That way there is a witness to the notice of delivery. So Jasmine and I, we or another leasing team member will accompany the person that's hand delivering.
Okay, and may I ask why you need a witness?
We would like to have a witness in the event that a resident wants to share that they were retaliated against or that there was any form of misconduct. Having more than just one associate provides that witness.
Okay, and there was an option in the notice to vacate to leave it on the door. May I ask why you didn't leave it on the door? Why did you decide to hand it in person?
Because that was an option. Hand delivery is an option, and that's the route we chose to take.
Okay, and when you knocked the way that you did, why did you choose to knock that way?
Your Honor, how is this relevant?
It's
I
relevant
don't-
because I'm
Hold on.
okay.
You
I'm
don't
sorry.
talk. You don't
Okay.
talk. She's made an objection. Okay.
Yes, sir.
All right. So the objection is relevance. I need your response why you think it's relevant.
Okay, I think it's relevant because I raised a retaliation claim, and the way that he knocked was, in my opinion, unprofessional. It was inconsistent with the kind of news that they were delivering, and I was just asking him why he knocked that way.
All right, I'll allow, but I'm not going to go very far into this. So
Okay, well, Quavius, can you demonstrate the way that you knocked on my door, please?
I will answer the question first. Our
Okay.
standard protocol, we will knock twice before we enter. The reason why we did not enter and post on the inside of the dwelling was because Jaron Humphrey opened the door. We knocked very standard. There was no aggression in that knock. I simply knocked like this
I
to
can't
make
hear
sure
it.
that I was heard.
all
I
right,
can't hear.
thank you.
I couldn't hear it.
It doesn't matter,
Okay,
honestly. Let's move
That's
on. Is there
fine.
any other questions you have for him?
not right now.
Okay. All right, thank you. All right, Mr. Boyd, do you have any other questions for Mr. Griswold?
No, I do not.
All right, thank you, sir. You're excused. Mr. Boyd, do you have any other witnesses?
Your Honor, I just need to call myself for attorney's fees.
All right, thank you. You may proceed.
My name is Erin DuBois. I'm a licensed attorney here in the state of Texas, and I was licensed in November of 2016. I practice with Rogers Law Firm here in Central Texas, and my primary area of practice is representing multifamily housing owners and management in litigation. I was asked to represent Shelby Ranch, the plaintiff in this case, and agreed to do so on an hourly basis. I charge $350 per hour and bill my time in tenths of an hour and tasks performed. In this case, I have reviewed the facts of the defendant's tenancy with my client's representative. I've reviewed the lease, the ledger, the notice to vacate, the justice court filings, the justice court answer from the defendants in this case, and some of the other ancillary documents that were filed in justice court. I reviewed the applicable statutes. I drafted the supplemental petition in this case, the notice of rent default. I prepared to conduct this trial and now tried this case. And in my opinion, the tasks that I have performed have been usual and customary. And I'm familiar with the guidelines set forth by the Supreme Court of Texas concerning attorney's fees and believe that I have adhered to these guidelines in all respects. It is my opinion that a reasonable and necessary fee for the usual and customary services rendered on the behalf of plaintiff in this case is an amount of $2,000. If this case were to be subject to a post-trial motion, I think a reasonable and necessary fee to handle that on behalf of Shelby Ranch would be an additional sum of $1,000 in attorney's fees. If this case were to be appealed to the Texas Court of Appeals, the task necessary to represent Shelby Ranch in that case would be to review the docketing statement, the clerk's and reporter's record, review any appellate brief, and drafting a responsive appellee's brief. And based upon my hourly rate of $350 per hour, I believe a reasonable and necessary fee to handle that on behalf of Shelby Ranch would be an additional sum of $5,000 in attorney's fees. If this case were to be subject of a petition for review to the Supreme Court, the task necessary would be to further review the clerk's and reporter's records, review the petition, drafting a responsive pleading. Based on my hourly rate of $350 per hour, I believe a reasonable and necessary fee would be an additional sum of $5,000. And if this case were to be granted a petition for review, I would further review the clerk's and reporter's records and review the full brief on the merits and draft a full responsive brief on the merits. And I believe that attorney fee, a reasonable and necessary attorney fee for that representation would be an additional sum of $5,000. And all of those amounts would be contingent upon my client prevailing at each stage post-trial. Your Honor, I have provided to the court via box, and I can screen share if you'd like.
Please do so.
There we go. Plaintiff's Exhibit 4. This is a true and correct copy of my activities export with Rogers Law Firm showing the work that's been done on this case prior to today's trial. And I offer that.
Any objection? Okay, hearing none. Plaintiff's Exhibit 4 is admitted. Mr. or Ms. Humphrey, do you have any questions for the attorney regarding fees?
No questions.
Okay, thank you. All right, Ms. DuBois, anything else?
No, Your Honor, plaintiff rests.
All right, thank you. All right, now, Ms. Humphrey and Mr. Humphrey, as I promised, you have an opportunity now to present any testimony or position that you'd like. No legal argument, but certainly facts that are presented would be appreciated. The legal argument you can do at the end when we do the closing statements. But as far as discussion of the facts, either one of you may call one another to testify. You can testify in narrative form. Ms. Humphrey indicated she didn't download or didn't bring any exhibits or documents, but she certainly indicated she wanted to say a few things, and maybe Mr. Humphrey as well. So would you like to call someone to testify?
No, sir.
Not at all.
I don't have any. Well, I don't have any witnesses. I just
Do you want to call yourself to testify?
Yes, sir. Sorry.
No. I just want to make clear okay. Yeah, that's fine.
Okay.
Ms. Humphrey, you may testify in narrative form, or you can have Mr. Humphrey do the direct questions and answers. But you can just testify in narrative form. You don't have to ask yourself a question like you're a third person or anything. You just kind of testify. Go ahead.
Okay. Well, I'll try to keep it short because I don't want to break any rules. I My testimony is that I believe that Quavius and Jasmine retaliated or they acted in retaliation. And I don't believe that Quavius has been completely honest and forthcoming, either with his superiors or with Aaron. If she knows, I don't, whether she knows the full truth, I don't know. But I just don't believe that there has been full honesty. So
Okay.
that's the testimony that I have.
Okay. All right. Mr. Boyd, do you have any questions for Ms. Humphrey?
No, Your Honor.
Okay, thank you. Mr. Humphrey, do you wish to call any witnesses or would you like to testify?
There's nothing, sir. I didn't find out about these problems until it was basically too late. So,
Okay.
if I can get a payment plan on this, see what we can do.
Okay. All right. Thank you. All right. Unless there are any other witnesses, I think the defendant has rested. So we're now ready to proceed with closing statements. Ms. DuBois, do you have
Yes,
one?
Your Honor. Evidence here shows that my client does have a superior right to possession of the property due to the failure of the defendants to pay rent. Concerning any claim for retaliation, Texas Property Code 92.33 3, I believe, states specifically that notices to vacate for non-payment of rent are statutorily non-retaliation. And so my clients have not retaliated per the Texas Property Code, and we are seeking possession as well as the award that is owed for the back due rent and the attorney's fees.
All right. Thank you. Mr. or Ms. Humphrey, do you have any closing statement you'd like to offer?
I have a quick question. So if there is an ongoing case and a landlord acts in retaliation as the case is ongoing, is that something that the judge is able to hear about?
I normally don't answer questions in closing statements. It's as far as the order goes. If there's something that you wish to complain about after an eviction has begun, that's probably a separate issue completely.
Okay.
What this court is dealing with right now is a contract, a notice, and whether there's been a breach of the lease
Okay.
and whether the eviction is valid under law.
Okay.
Any other things you would have to deal with separately, I think.
Okay.
But this is the only thing I'm dealing with right now is the pleadings in front of me, and
Okay.
what was argued today, and what evidence was presented today.
Okay.
Okay. Anything else?
That's all. Thank you.
Okay. All right. Thank you very much. All right. Court will find in favor of the plaintiff as far as the lease agreement not being complied with as far as payment goes. I'll find that the plaintiff is entitled to possession of the property, that the defendant is liable for the sum of $6,570 and any court costs and post-judgment interests minus the amounts that are already in the registry of the court, which I believe is 2628 already. I'm going to also find that the attorney's fees to be awarded to the plaintiff are $2,000, and then there will be conditional fees. These are only if these conditions occur. If there's a post-judgment motion and hearing and the plaintiff is successful, attorney's fees will be awarded to the plaintiff of $1,000. If there's a court of appeals matter and the plaintiff is successful, $5,000. If there's a petition for review before the Texas Supreme Court and the plaintiff is successful, $5,000. And if the court grants a petition for review and then here's the case and the plaintiff is successful, then an additional $5,000 in attorney's fees will be awarded. I'm going to set the supersedious bond on this matter at, hold on just a second. I'll set the supersedious bond at $3,942. Wait a minute, did I do that math right? Yeah. $3,942, which will be due within 10 days of this order. And then continuing amounts in the event the case continues on appeal, the sum of 1314 will be due by the 5th day of every month thereafter, successive month thereafter, as the appeal continues. So that means that it would be due by April 5th of 1314. Those are the additional amounts if the appeal goes forward. And I presume there's already an order for me to sign, but if not, y'all can send that to me.
Your Honor,
And-
I have sent a proposed order to
Okay.
Ms. Raines Walker. Do you want me
Okay.
to go ahead and e-file that as well?
No, if you've already sent that to Ms. Walker, I'll take care of that.
Okay.
All right. Thank y'all for the courtesies, and I'm sorry things have turned out the way they have, and I'm
I'm
gonna let
sorry.
y'all go. I need to move along. Thank you.
It cut
Y'all are
out and
excused.
I couldn't hear you because my Zoom cut out. So there was a part right before you were talking about the April rent, or I couldn't hear you because I
Okay,
had to.
so the supersedious bond,
Okay.
I've awarded in the matter, which means that if you want to keep going, if you do appeal this, within 10 days of today, $3,942 in the registry of the court. And then thereafter, as the appeal continues, monthly amounts due by the 5th of the month in the sum of the monthly rent of 1314 would be due in the registry of the court by the 5th day of every successive month thereafter.
Okay, got it.
All right.
Thank you.
Thank you. I appreciate it.
Thank you, Your Honor.
All right.
Bye.
You'll have a great
Thank
rest
you.
of the day. Thank you. All right. CB 26-0453 Mid-America Apartments versus Ms. Wells. If you would go and make your appearance for the record, beginning with counsel for the plaintiff.
Good morning, Your Honor. Corey Rogers appearing on behalf of the plaintiff in this case. I'm accompanied by Cleo Smith. She's the assistant property manager for the property.
Thank you. And then Ms. Wells, you're present this morning?
Yes, sir.
Thank you. Thank
Yes,
you.
sir.
Appreciate that. All right. Okay, this is a de novo appeal. I see there's a notice of rent default under 5109C and request for writ. So the court will take that issue up first, and then we'll go to the main part of the case. And with that being said, Mr. Rogers, you may proceed.
Thank you, Your Honor. This is the appeal of an eviction for non-payment of rent from the Justice Court. The defendant appealed the judgment. Judgment was January the 8th. They did appeal. They did make their Justice Court registry payment. However, they did not make a February payment into the county court. And so on that basis, we filed a motion under Rule 510.9C seeking an immediate writ of possession.
All right. Thank you very much. Ms. Wells, did you make that payment required for the February rental payment?
Yes, sir. I tried to make that payment, but I wasn't able to make the full payment. But I did talk to the county clerk. They gave me a 10-day notice to pay the 1318 if I can by next week.
That would be interesting. Do you have a copy of what you're claiming they sent you? I'd be interested to see that if they're doing that.
I talked with the representative on the phone.
Okay. But they didn't send you anything indicating that there would be a 10-day
N-
grace
no.
period of some sort?
No,
Okay.
sir. No, sir.
Okay.
No, sir.
Okay. Okay. But the payment hadn't been made, right? For the month of
No,
February?
sir.
Okay. All right.
No, sir.
Okay.
The reason why the rent was late, just period, is I just fell into hard times. I lost my job and things like that, and
Okay.
I'm trying to get up and get myself together. I don't want to lose the apartment. I don't want to mess up anybody's credit. I know everyone needs their money and stuff like that,
Sure.
but I'm still willing to work with the property as much as they're willing to
Okay.
work with me.
Right. Well, here's what we're going to do.
Yeah.
I'm going to need to go forward on this, and unless they tell me otherwise, what can happen is I can issue orders based on the case, but then parties can still
So
work
that I see,
things out afterwards.
I'm sorry, sir. I'm sorry. I just have, I see that Corey already drew up the papers as far as like the motions and all the cases. So I'm just nervous, and I'm just needing to know as far as how quickly you're wanting to proceed with the case.
I'm proceeding now, ma'am. We're moving forward on the
I'm
case
saying
now.
as far as like defaulting a judgment, if that makes sense.
If a judgment is rendered today, it would be signed today, and when an eviction, when there would be a writ of execution, et cetera, is really kind of up to the party seeking it and how quickly the deputies go ahead and execute on it. So,
Yes, sir.
okay. All right.
Yes, sir.
Like I said, I'm going to move forward on it now, unless the plaintiff tells me otherwise. But then, no matter what I do today, the party still can talk. So it doesn't foreclose that at all. Okay. Y'all can still talk after this is done. Okay.
Okay.
Thank you,
Yes,
Ms.
sir.
Wells. All right. So on the 510-9C motion, a party's obligated to continue to make monthly payments in the registry of the court. And that hasn't been done, which Ms. Wells noted. And the court is certainly empathetic and sympathetic on that count, on inability to kind of cover things as situations arise. But I have to follow the law,
Yes, sir.
and I'm going to go ahead and grant the immediate writ of possession favoring the plaintiff, which means they're entitled to the property immediately. But they don't often get that executed for a few days. Handled by the deputies. But I'm going to sign that order
Because
today.
I'm like,
But y'all,
my family is, I'm not from here.
I understand.
I'm not from
But
here,
ma'am,
so
I need to finish. I need to finish what I'm doing here.
I'm sorry, sir. Yes, sir.
So that order is going to be signed, and now we're going to go to the main part of the case. Now, you and Mr. Rogers may have already talked about this, as far as you may agree that the rent hasn't been paid and that there's been a breach of the lease and that they're entitled to the property in certain amounts. If y'all have already done that, or y'all had that discussion, then the trial may not be, the full-blown trial part may not be necessary. That's only if y'all have agreed to it. If you haven't, I'm ready to proceed.
We haven't agreed to it, but if Ms. Wells wants to agree about, the admission of the exhibits and the delinquency that's in play, I'm certainly happy to try to streamline things.
Yes, sir. I haven't spoken with Corey personally, but like he just said, I'm able to work with the property if they're willing to work with me.
Okay. Well, that's something else. I need to move forward on it. So I'm going to have Mr. Rogers can give an opening statement, and then Ms. Wells, you can give a brief opening statement, and then they can present their evidence, which I presume will be documents memorializing your relationship with the apartment complex and notices they may have given you and things like that. So that's what we're going to do now. Mr. Rogers, you may proceed with your opening statement.
Thank you, Your Honor. This is an eviction that's based upon non-payment of rent. Rent has been unpaid since December of 2025 through the present. The monthly rent's $1,318. We're going to be asking for a total of $5,272 in back rent, plus possession of the apartment and attorney's fees today.
All right, thank you. Ms. Wells, do you have an opening statement? And if you do, let me go ahead and swear you in. Let me swear any witnesses who may be testifying today. If you wouldn't mind, even though I can't see you, Ms. Wells, if you would please raise your right hand. And Ms. Smith, you may also as well. And Mr. Rogers already is. Do you solemnly swear or affirm the testimony you're about to give in this matter shall be the truth, the whole truth, and nothing but the truth?
I do.
Yes, sir.
Thank you. Thank you. And Ms. Smith, thank you. You'd have to take yourself off mute so I can hear you say I do.
Yes, I did.
All right. Well, you and I aren't married, but I do marriage. I do weddings. So, but we're all together. Okay. Um, all right. So Ms. Wells, do you have an opening statement? Do you have anything to say?
No,
Just
sir.
briefly.
No, sir,
Okay.
Your Honor, I don't.
Okay.
I
Thank
just
you.
know I just know I fell on hard times, and I know the property is, like I said, everyone needs their money and stuff. But like I said, I'm willing to work with them as much as they're willing to work with me.
Yes, ma'am. Okay.
So that's why I'm willing to come to court and everything. So,
Oh,
yes,
well,
sir.
I appreciate that. All right, Mr. Rogers, you can call your first witness.
Thank you, Your Honor. I'd like to go ahead and call Ms. Cleo Smith to testify.
Hi, Ms. Smith. You've already been sworn in, and
Hi.
good morning,
morning,
Mr.
Your Honor.
Rogers. Good morning, Mr. Rogers. You may proceed.
Thank you. Good morning, Ms. Smith. You work for Mid-America Apartments LP, doing business as MAA Wells Branch, correct?
Correct.
And you're the assistant property manager there?
Correct.
And you're familiar with the tenancy of Ms. Enzia Wells?
Correct.
It's
And
in
Ms.
Zaya.
Wells,
I'm sorry.
Zaya.
It's in Zaya.
And Zaya.
Enzia, I'm sorry, Ms. Wells. Yes. So you're familiar with the tenancy of Ms. Wells?
Correct.
Yes. And does she reside at 1630 Wells Branch Parkway, apartment 715, Austin, Texas, 78728?
She does.
And is that address within precinct 2 of Travis County?
It is.
And is her occupancy based upon written lease?
It is.
Your Honor, permission to share my screen.
Of course, thank you.
Ms. Smith, go ahead and take a look at what I have shared on the screen and marked as Exhibit 1. Do you recognize that document?
I do.
Is that the lease agreement between the plaintiff and the defendant in this case?
It is.
Your Honor, we'd offer Exhibit 1 into the evidence, plaintiff's 1.
Thank you. Any objection to Exhibit 1, the lease?
Nothing.
Hearing none. Thank you. Plaintiff Exhibit 1 is admitted.
And Ms. Smith, pursuant to this lease agreement, and specifically the lease details section here, lease summary in specific terms, the monthly base rent is the amount of $1,318, correct?
It is.
And did Ms. Wells fail to pay that rent and utilities in violation of paragraphs 1.1 and 9.1 since December of 2025?
She did.
And that failure is a default under paragraph 15.1, which entitles the plaintiff to possession?
It is.
So you're asking for $1,318 for each of the months of December 2025 through March 2026 for a total of $5,272.
I am.
And then pursuant to paragraph 24.6, are you asking the court to award your reasonable and necessary attorney's fees at trial here today?
I am.
Actually get to that paragraph. Okay. Go and take a look here at what I've marked as Plaintiff's Exhibit 2. Do you recognize this document?
I do.
Is this a true and correct copy of the notice to vacate that you delivered to Ms. Wells?
It is.
And you delivered it by posting outside and mail on December the 5th of 2025 in compliance with, yeah.
I did, yes.
Your Honor, we'd offer Plaintiff's 2 into the evidence.
Thank you. Any objection to Exhibit 2?
No, sir. No, Your Honor.
Okay, thank you. Plaintiff Exhibit 2 is admitted.
And after this notice was delivered, did Ms. Wells, did she make any payments at all, or did she vacate the apartment?
She did not.
Okay. I'll pass the witness, Your Honor.
Okay, thank you. Ms. Wells, do you have any questions for Ms. Smith?
No, I did not.
Okay, thank you. All right, Mr. Rogers, your next witness.
I'd call myself to testify about attorney's fees, Your Honor.
All right, thank you. You may do so.
Thank you. My name is Corey Rogers. I'm an attorney and counselor licensed by the Supreme Court of Texas in May of 2008. I practice with Rogers Law Firm, and my primary area of practice is trial work with an emphasis on multifamily housing representation. I agreed to represent the plaintiff in this case, doing so on an hourly basis at the rate of $400 per hour, billed in 10th-hour increments. I keep detailed time records, and basically in this case, I've reviewed and analyzed the relevant documents, corresponded with my client, drafted supplemental pleadings and motions, prepared to conduct this trial and now tried this case. It is my opinion that the tasks I have performed have been usual and customary, and I'm familiar with the guidelines set forth by the Supreme Court of Texas regarding attorney's fees and have adhered to those guidelines in all respects. It is therefore my opinion that a reasonable and necessary fee for the usual and customary services in this case to be the sum of $2,200. I'm further familiar with the process and the procedures for this case to be the subject of a post-trial motion and believe that a reasonable and necessary fee to handle that would be an additional sum of $1,000. I'm also familiar with the process and the procedures of this case were it to be appealed to the Texas Court of Appeals and the tasks necessary, which would include review of the docketing statement, review of the clerk's and reporter's records, review of the appellant's brief, and drafting a responsive appellee's brief based upon my hourly rate of $400 per hour. I think a reasonable and necessary fee to handle that would be an additional sum of $5,000. I'm further familiar with the process and the procedures were this case to be the subject of a petition for review to the Texas Supreme Court and the additional tasks necessary, which would include further review of the clerk's and reporter's records, review of the initial pleading, and then drafting an initial responsive pleading based upon my hourly rate of $400 per hour. I think a reasonable and necessary fee to handle that would be an additional sum of $5,000. Finally, I'm familiar with the process, the procedures where this case to actually be granted a petition for review and the additional tasks necessary, which would include further review of the clerk's and reporter's records, review of the full brief on the merits, and drafting a full responsive brief on the merits based upon my hourly rate, $400 per hour. I think a reasonable and necessary fee to handle that would be an additional sum of $5,000, with all post-trial amounts being contingent upon my client prevailing. I would also offer into the evidence, Your Honor, Plaintiff's Exhibit 3, which I currently have shared on the screen. That is an itemization of my attorney's fees time prior to trial here today.
All right. Thank you very much. That's admitted. Well, I'm sorry. Are there any objections to Exhibit 3?
No, yeah.
Thank you. I apologize on that. Plaintiff's Exhibit 3 is
No, you're
admitted. Ms. Wells, do you have any questions for Mr. Rogers?
Is there any way I can contact him after the court session, or that's not
You
possible?
certainly may. You certainly may. The only questions right
Okay,
now are about his fees themselves. Would you like to talk to him
No,
afterwards?
Yes, sir.
Okay. All right. Well, thank you.
Sure.
All right. I assume plaintiff rests.
I do, Your Honor. I did, it's a little bit of a moot point just for housekeeping. I did ask for a supersedious bond in the final judgment. I set it as the monthly rent 1318 due within 10 days, and then the first of each subsequent month.
I think I got that email yesterday. I'm sorry to cut you off, Corey. Did I get that email yesterday? Is that the email that you sent me?
Those were the exhibits.
Okay. That's the paperwork that you just pulled up and you're waiting for Mr. Hong to sign off on, or the judge.
Well, I sent the exhibits to you yesterday. The other paperwork was filed about a week ago.
Okay. And okay. Yeah. Okay.
Okay.
So is
Okay.
there any agreement that we can come to, or there's no agreement that you would like to come to?
We need to talk after Judge Wong gets done with what he's doing.
Okay.
We'll talk
Okay.
offline.
I'm sorry,
Not-
Corey.
you
I'm
can-
sorry. I'm sorry.
That's
Okay.
okay. You can
Okay.
call. I have another hearing after this, but can I
Okay.
call you when I get done?
Yes, sir, you can.
Okay. And the phone number that's on.
It should be.
Don't say your phone number. We're live. Don't say your phone number.
Oh, okay.
I'm sure I have your
I'll
phone
email
number.
that
I'll call
over
you.
to you.
Okay.
Okay. Yes, sir. Thank you so much.
All right. So all that being said, no questions for Mr. Rogers. So we're ready to do.
No, sir.
Okay. Thank you very much. All right. Plaintiff rests. Now, Ms. Wells, would you like to testify or present any evidence?
No, I think all the evidence that they have is realistic, so it's nothing, that I can say.
Okay.
I have to. I'm praying right now, so yes, sir.
Okay. All right. Very good. All right. Any closing statements, Mr. Rogers? Do you have one?
I think the delinquency is clear here. I'm sympathetic, falling on hard times. That happens to everybody. But my client has to operate a business, has to be able to provide housing to people that can pay. And so we're going to ask the court to go ahead and enter judgment.
All right, thank you. Ms. Wells, do you have any closing statement you'd like to offer?
No, sir.
Okay. All right. Well, thank y'all very much for the courtesies extended. I'm going to rule that the plaintiff is entitled to possession of the property from the defendant, that there was a breach of the lease as far as making timely payments. I'm fine that the plaintiff is entitled to the property, that they're entitled to damages in the amount of $5,272 in this matter, plus post-judgment interest at the legally allowable rate, which I think is 6 3/4. Their entitled possession, I think I already said that. Their attorney's fees, which I find reasonable necessary attorney's fees, which I find to be in the amount of $2,200. Post-judgment, in the event these conditions occur, these are the award of damages. If there's a post-judgment hearing in motion, the plaintiff is successful, $1,000. If there is an appeal to the Court of Appeals and the plaintiff is successful, $5,000. If there's a petition for review and the plaintiff is successful, $5,000. And if the case goes to the Texas Supreme Court and they grant that petition for review and the plaintiff is successful, then an additional amount of $5,000 in attorney's fees. These will all be noted in the judgment, but they're all conditional. So that's what we have on that. I'm not going to sign a supersedis bond because I'm already signing the immediate writ of possession in the matter. And I do encourage the parties to talk if they can come to some sort of understanding or root, but these are the rulings that I'm making, and I'll sign the final judgments. And I appreciate the kindness that everyone is showing to one another and grace. And I hope that things can work out, but sometimes they can't, and you just have to kind of move on and try to make the best you can. So I wish y'all well. Thank y'all very much.
I'm sorry, I do have a question, Your Honor. I'm sorry.
What do you need, Ms. Wells?
I'm sorry. I'm just because I'm a little lost as far as like the court situation. How soon would I get that post of immediate judgment? Like, how would I sign that out, if that makes sense?
The court will probably be signing it today. It'll be online. You can talk with Mr. Rogers about how that will go beyond.
Okay.
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 All right.
Sir. Thank you so much.
Thank you. All right.
Thank you,
Have a
Your
great
Honor.
rest of the day. Thank you.
All right, bye.
Bye.
Sure.
C1 CV 25-6657, Elizabeth Gilbert, James Gilbert versus Pranitha Polaju. If you would, go ahead and make your appearances, beginning with the Gilberts counsel.
Mitchell Savrick, Savrick, on behalf of the Gilberts.
Thank you. And the movant defendant. Go ahead and take yourself off mute and just say that you're here.
Your Honor, I'm Pranitha Polaju, appellant defendant.
Thank you. Thank you very much. All right. This is a no evidence motion for summary judgment. Generally, we don't do a court record on that. It's just based on the documents that are filed. And so that's what we'll do this morning. This is the defendant's, the defendant's no evidence motion for summary judgment. So Ms. Polaju, you may proceed. Go ahead and take yourself off mute though before you start.
Thank you, Your Honor.
Go ahead.
Can you hear me clearly, Your Honor?
Yes, ma'am.
Thanks. Your Honor, for the record, my name is Pranitha Polaju. I'm the defendant appellant representing myself. This hearing is for my no evidence motion for summary judgment. To give the court a brief context, this is a de novo appeal. I filed it on October 14, 2025 from a justice court decision regarding a residential lease. However, the core of this dispute is incredibly simple. It is about a $4,000 security deposit. The delay in returning the deposit was not due to malice or dishonesty, but due to a communication failure by third party. I have not received a direct forwarding address or the move-out documentation at that time. I'm asking the court to grant the motion today because plaintiffs have zero evidence to support their claims of bad faith or their newly amended claim for breach of contract. And their entire case relies on a demonstrably false affidavit. If I may a little bit further explain, at a very high level. First, all this is documented in my filings since October. First, regarding the forwarding address under the Texas Property Code 92.107 and our lease agreement, providing a forwarding address is a conditional precedent. Landlord is not obligated to return a deposit until the address is provided. Plaintiffs never provided their address directly to me. Maybe they relied solely on the text message to former property manager. However, as shown in my filings, Mr. Auberg, who is the property manager, texted plaintiff who they were in contact with. It's quoted as question for her. We never had it in first place. She took over. So because that the condition precedent was never met, there is no breach of contract. In fact, the plaintiffs never shared their address with me until I received a notice from the JP court that they had sued me for $12,000 back in August 9, 2024. Second, regarding bad faith claim, I actually tendered a full $4,000 security deposit to the plaintiff in November 2025 to resolve this, right after I filed my appeal and in communication for settlement with the plaintiffs. They actively rejected the check. Texas law does not reward plaintiffs who refuse full payment of a debt payment just to drive up litigation costs and gamble on treble damages. Finally, Your Honor, regarding the plaintiff's evidence, which was submitted in the documentation by the plaintiffs, to survive this summary judgment, plaintiffs submitted a sworn affidavit last week claiming they never received my $4,000 check. This is perjury, I feel. And as shown in my Exhibit 1 to the response, Mr. Gilbert sent me an email on November 11th, 2025, stating, again in quotation, we have reviewed your filing and noted the 4,000 check. We do not accept 4,000 as a settlement. A party cannot create a fake fact dispute to survive summary judgment by submitting a sham affidavit that directly contradicts their own written emails. Because the full $4,000 were tendered and rejected, because they have failed me to provide a forwarding address back then, and because their affidavit is sham, I respectfully request the court to grant my no evidence motion for summary judgment.
Thank you very much. Ms. Safford.
Good morning, Your Honor.
Good morning.
Just to put this into context, this is a no evidence motion for summary judgment. The movant hasn't, she didn't attach any evidence to her motion. She did a response to a reply that had to be corrected because she had a false affidavit, a false piece of evidence in there and that she corrected. But it's really based on our evidence. That's the whole idea of a motion for summary judgment, is not to get into a no evidence motion for summary judgment, is we don't get into these swearing matches. You look to the evidence that we put forth in the reply and you decide if it's enough evidence to support the issue. Her motion is not on the claim. Her motion is on one of the issues involved in the security deposit fight, and that is whether there's bad faith to justify the treble damages under the statute. Bad faith is not just late filing, late return of the security deposit. The court can find bad faith for a number of different reasons. It's presumed if the itemization and the return of the security deposit isn't returned within 30 days, but that's not the sole basis for finding bad faith. She seems to be arguing mainly that she was not untimely with the return of the security deposit because there wasn't a timely forwarding address. That seems to be the big part of her argument. But there is ample evidence in this case that's in our summary judgment evidence to support the concept that the movement acted in bad faith. And it starts with this. She had and this is all in our summary judgment evidence. She had a property manager handling the move out issues. Thus, the forwarding address was provided to the property manager. 3 days after it was provided, she fired the property manager in there. 30 days goes by. Oh, and by the way, the property manager, it's in writing, said the property was left in great condition. They did an amazing job of repainting and fixing it up, and that it was in very good condition. That is in the summary judgment evidence. 30 days goes by, and the Gilberts write to her and say, hey, we didn't get the security deposit return. She sends back to their new address within a matter of days. She sends back to them an itemized statement and none of the money. The itemized statement has charges that in our summary judgment evidence we say is bogus and contradicts her own property manager's on the ground inspection. You may recall in open court, the movant said she hadn't been back to the property and back to Austin in 2 years. She never saw what was there. She fired the property management, turned back an itemization, had no evidence to support it. None whatsoever to support. And we say these are all bogus charges. As a result of that, the lawsuit was filed in JP court. She answered the suit not with it was just timely or I have all these charges, but she said there's no security deposit. She denied there even being a security deposit on this. After she lost at JP court, after the JP court found that there was bad faith on there, she writes a letter and sends him an email that she's going to send the $4,000 to them. Our client emailed back and said, look, I mean, they were sitting on a judgment with $12,000. $4,000 to settle this claim isn't enough, but they never get the check. They put in summary judgment that she never sent the check. And I have told her this many times. We never got the check. The clients never received the check. So she says in her motion, but no real summary judgment evidence, I sent them a check. But their testimony, that is what you have to rely on, says she never sent the check on there. Now she seems to be saying in the appeal, I understand that I owe them the $4,000, but I've sent them the $4,000. After the judgment was for approximately $12,000 in the JP court. There is ample evidence to set this to the fact finder, whether that's you or whether it's a jury, to sit there and say that the movement acted in bad faith. Bad faith is inherently a fact issue. It's not a legal issue. And based on the summary judgment evidence that we've put forward, there is ample evidence of bad faith. Now, I did make a motion, I did make an objection to the fact that if you feel there's not enough evidence, and Judge, I feel there's more than enough evidence for a finding of bad faith, but the movement has denied me the opportunity to take her deposition before this. If you recall, we had a hearing about Zoom, went to do Zoom, and it was ordered that she should appear. I begged her for dates before I had to file a response to give me a deposition date, and she would not give me a deposition date until after March. I don't want to waste the court's, until after this hearing. She said, let's have this. She wouldn't give me a date to come to Austin to do her deposition. I had to file my response. I filed my response. I made the objection. I don't really want to waste the court's time on this issue. I think there's absolutely enough evidence to have a finder of fact decide whether there's bad faith on there or not. We're gonna have a trial anyway on the $4,000 and attorney's fees and all that. And the issue of bad faith should be decided at that time based on the evidence. I know she doesn't believe the evidence. She thinks she has evidence to contradict that, but that's not resolved in a no evidence motion for summary judgment. And we would ask that the court deny her motion.
All right. Thank y'all very much. Anything else? No?
Your Honor, it's fine.
Yes.
Okay.
Yes, go ahead.
So, Your Honor, my no evidence summary judgment, I have clearly attached in my timeline, chronological order, and also rebuttal, and not just these 4 or 5 points in bad faith, especially for bad faith. I have been filing all my responses on time as I received the documents, and I have provided all my backing and explanation over last 4 months. And today I'm hearing is that it's again for bad faith and that I have denied security deposit and I have not been collaborative in responding to Mr. Mitchell. These are the things I'm hearing, but I want to again explain from my end.
Ma'am, please understand, this is not the only thing the court considers is what's on file that was
Yes.
filed in this part of the case.
Correct.
So you telling me other items, it's not evidence in front of me. Okay.
Yes.
There's nothing. You can only go with either arguing what you filed, or if you've somehow filed something else in response to him. Okay. Because that's the only thing that in a summary judgment motion, that's the only thing a higher court would look at is whatever. There's no record. It's just what's filed. Okay.
Yes. Yes.
Okay.
I'm just pointing out to what I have already filed. And I have filed all the exhibits due as my response. And
Ma'am, please just get to your argument so I can finish this hearing today. Okay.
Okay.
Thank you.
So my argument here is that one second, I'm just looking at my notes. So my plain argument is that please grant the motion for no evidence summary. And since it is about the security deposit, which I have tried to give back, and I am trying to please help me with close the case and help me provide me the closing the no evidence motion for summary judgment. And my entire argument is order that plaintiff take nothing, no attorney charges, no other things other than just the security deposit.
Thank you, ma'am. I appreciate that. Mr. Savrick, anything else?
Judge, no, I think, like I said, in our summary judgment, our affidavit are attached, the emails, everything we have. We believe there is ample evidence, not only to get over the hump of her motion, but to actually establish bad faith in this case, which is what the JP court decided.
All right. Thank you very much. I appreciate the motion from Ms. Bojalou and also the response. In a no evidence motion for summary judgment, if there's some evidence at all, those are denied. And in this case, because of what I'm looking at here, I'm going to deny the no evidence motion for summary judgment. I'm going to urge the parties to follow my prior rulings about getting this deposition done timely. If it's not done timely and there's a follow-up motion on it, I will consider other acts that the court can do to enforce these things. I don't want to have to do that. This is a pretty simple matter. Get it done so we can get it tried either before me or Judge Shepard or trial before a jury. But let's get this done, okay? Y'all shouldn't be tied up in this very long. I don't. When I see these cases, I take a second look at it, kind of going, why is this taking so long? And why are they arguing about so many things when it's a pretty simple matter? Both sides, tell your clients and the party here, do not be stubborn about this thing. Try to work it out, okay? If you can't, you may not be happy with the results if you're letting a jury decide or you let a judge decide. So if y'all can work it out, great. If you can't, I'm happy to do my job, and I'm sure a jury would be happy to do their job too. All right, thank y'all. Ms. Savrick, I need an order saying the motion's denied.
We downloaded one both in the box and in the system.
Okay, thank you very much. We'll take care of that. I wish y'all well. Continue to talk. Try to be open to trying to get things taken care of. Thank y'all very much. Y'all are excused.
Thank you.
All right, let's go to the next case. Kathy, well, you didn't have to. Well, I still want to see you doing all right.
I'm here, Judge. Yes.
Okay. Randy, Morgan, y'all doing all right? Can we finish this?
Yes, and then
Okay.
the defendant has logged off, so it's just Mr. Rogers again.
Okay. CV 25-7434 Mobile Loaves versus Sarah Black. Why does this camera keep messing around? There's something going on here. Good morning, Mr. Rogers again.
Hello again, Your Honor.
All right. C1 CV 25-7434 Mobile Loaves and Fishes Inc. versus Sarah Black. She has filed a motion to set aside judgment. Judge Shepard has previously denied a stay of the writ of execution. The movement had set this for a Zoom here, had set this for a hearing, agreed to Zoom, apparently has been online, but then either decided to drop off or was accidentally dropped off. I don't believe my staff has received any word from her that she's having any technical issues. And so, Mr. Rogers, you want to make your appearance?
Yes, Your Honor. Corey Rogers appearing on behalf of the plaintiffs and respondent to this motion in this case.
Thank you. As the court has stated before, or just a moment ago, Ms. Black was online. She apparently has dropped off the Zoom call. The time is 10:27 a.m. My staff has not received any word from Ms. Black as to why she dropped off, any communication issues. The court is looking at the motion, but there's no one to present it. I'm going to deny it. I'll sign an order, and I appreciate your time, Mr. Rogers.
Thank you, Your Honor. I do believe that an order has been e-filed for the court, but if I'm somehow
All right.
mistaken,
We will let you know.
perfect. Thank you, Your Honor.
All right.